Picture this: a thriving company on the rise, venture capital flowing in, and a CEO at the helm. But what happens when the tides turn and the board of directors loses faith in its leader? Can the board remove him without notice? Klaassen versus Allegro Development Corporation explores these questions. In 1984, Eldon Klaassen founded Allegro Development Corporation. Klaassen served as Allegro's CEO and, up until 2007, was Allegro's sole shareholder. In 2007, Allegro solicited capital infusions. Two venture capital firms invested $40 million in exchange for preferred stock. Allegro, Klaassen, and the investors entered a stockholders agreement and amended the corporate charter and bylaws to reorganize Allegro's board of directors. Under those documents, the investors were entitled to elect 3 directors, the common stockholders were entitled to elect 1, and the remaining 3 directors were designated by the CEO and approved by a stockholder vote. In practice, Allegro operated with a 5-member board with 2 directors elected by the investors, 2 outside directors, and Klaassen as CEO. Unfortunately, soon after the investment, Allegro's revenues started to drastically decline. The board became frustrated with Klaassen's performance and management. By the fall of 2012, the board sought to remove Klaassen as CEO. On November 1st, at a regularly scheduled board meeting, 4 directors voted to remove Klaassen as CEO and appointed an interim CEO. Initially, Klaassen offered to help with the interim CEO's transition and negotiated with Allegro regarding a consulting agreement. However, at some point, Klaassen began expressing displeasure with his removal. In June 2013, Klaassen sent a letter to the board claiming his removal was invalid and purporting to remove the outside directors and elect new directors. Klaassen also filed an action for declaratory relief, arguing his removal was invalid because the board didn't give him advance notice of his termination and employed deception in its decision to terminate. The directors countered that Klaassen's claims were equitable and barred by the equitable defense of acquiescence. The Chancery Court agreed with the directors. Klaassen appealed to the Delaware Supreme Court.